charged with the offense in count one of aggravated kidnapping. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine.
Welcome to the Court of Justice.
2023 CR 2763E, State of Texas versus Lazaro Alfonso Estrada Pedez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Miguel Hernandez for the defense.
And is there a plea on one case only?
Yes, Judge, it should be on 2023 CR 2763E. There is something I wanted to bring up about discovery though, but we can do that whenever that comes up.
All right. Are you Mr. Estrada Pedez?
Yes.
All right. Okay, off the record for a moment. All right, everyone, do not approach the coordinator when I'm on the record. Everyone, this is the last case I'm calling before lunch. So everybody else, we've been here since 9. You'll need to be back at 1:30, the end. All right, we're back on the record. Are you Mr. Estrada Pedez?
Yes.
Are you the interpreter?
Yes, Your Honor.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Norma Nero.
Mr. Estrada Pedez, all of the documents that I'm going to review with you, they are in English. For those documents, review with you in Spanish.
Yes.
And counsel, do you speak Spanish?
I do, Your Honor.
And do you speak it fluently?
I do, Your Honor.
And have you been able to communicate with your client in Spanish?
I have, Your Honor.
Counsel, have you received all the discovery? Did you review it with your client?
We believe we have, Your Honor, and I have looked it over much as I can.
All right, and state.
Judge, so the reason why I wanted to bring this up is that there were 2 discovery acknowledgements filed in this case. One of them for this case number, but then another one filed for the accompanying case number. My understanding is that on Verifake and e-discovery, it shows up all the discovery on the other case, but it's the companion one to this one. So I'm just making sure the defense had access to that other one. I remember dropped off a hard drive and I gave him a copy of everything.
We have, Your Honor, and we did look at everything.
All right, the court will find that the state is in compliance with discovery. Mr. Estrada Pedez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on count 1, waiving count 2.
Any objection?
None at all.
Mr. Estrada Pedez, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense in count 1 of aggravated kidnapping? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine.
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Estrada Pedez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
No.
Anyone promised you anything other than the plea?
No.
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, did you advise the defendant on his immigration status and the impact this plea would have upon him?
Yes, Your Honor, and he did have an interview for a Padilla letter, and they recommended, of course, that something a lot less than being offered, but because it is serious felony. And knowing all that, he's permission to follow the agreement.
Mr. Estrada Pedez, did you have a chance to speak with an immigration attorney concerning the impact this plea would have on your immigration status?
Yes.
Do you remember that attorney's name?
No,
No, I don't remember.
This may to- It was from the public defender, so yes, it was Miss May Sarah.
All right. Did she advise you of the consequences of pleading no contest or guilty and the impact it will have on your immigration status?
Yes.
That advice include possible consequences such as deportation, the denial of naturalization, or re-entry into the United States?
Yes.
And do you understand the impact this plea will have on your immigration status?
Yes.
And knowing the impact this case will have on your immigration status, do you still wish to go forward with the plea?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney and did you understand it?
Yes.
According to the plea, the state is proceeding on count one. They're asking that your punishment be assessed at 10 years in the prison. There are no applications. They're taking in consideration 2023 CR 2764E. Did you also understand that if the court find that there was a deadly weapon involved, the court will find a deadly weapon finding?
Yes.
Did you understand that to be the entirety of your plea?
Yes.
State, is that the plea?
Yes, Your Honor.
Defense, is that the plea?
It is.
Did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to count one, paragraph A and B, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State all proceeds to exhibit what are all attachments.
We have a chance to review, Your Honor, no objections.
Thank you. Mr. Pedez, did you have a chance to review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. After reviewing state's exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
We would ask that you follow the plea bargaining agreement made with the state, Your Honor, and propose a 10-year sentence.
All right, anything you wish to say, Mr. Estrada Pedez?
No.
All right, the court will find you guilty. The court is going to sentence you to 10 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. Take in consideration 2023 CR 2764E. Is there anything else with regards to sentencing?
No, Your Honor.
Did you review the document entitled Trial Court Certification with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
All right, and I'm also going to put in the judgment, no illegal re-entry into the United States. All right, if you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Mr. Estrada Pedez, in this world, you have to learn one thing. And that one thing you need to learn is you cannot build your happiness on somebody else's misery. Do you understand?
Yes.
All right, good luck to you.
No, we excuse, Your Honor.
You're excused. All right, Norma, these are the people who are coming back at 1:30.
Maybe excuse your.
Yes, thank you so much.
The courtroom is tense as Judge Stephanie Boyd calls the case of the state of Texas versus Lazaro Alfonso Estrada Pedez. The charge is grave: aggravated kidnapping, a first-degree felony carrying a potential sentence of 5 to 99 years or even life in prison. From the outset, Judge Boyd methodically establishes the record, ensuring the defendant understands the terrifying magnitude of the charges against him. The state moves forward on count 1, proposing a punishment of 10 years in prison, a significant sentence, yet a fraction of the maximum time he was facing. But then, Judge Boyd pivots to a line of questioning that foreshadows a consequence arguably as severe as the prison time itself. She confirms the defendant is not a U.S. citizen and meticulously verifies that both his attorney and an immigration lawyer have warned him about the catastrophic impact this felony plea will have on his status. She gives him every opportunity to halt the proceeding, asking pointedly if, knowing these devastating collateral consequences, he still wishes to plead. His quiet yes seals his fate on 2 fronts. With his plea of no contest entered, Judge Boyd finds him guilty based on the state's evidence. She then delivers the hammer blow, sentencing Lazaro Alfonso Estrada Pedez to 10 years in the Texas Department of Criminal Justice. The sentence includes a deadly weapon affirmative finding, further complicating any future hope for clemency or early release. Judge Boyd's final admonishments, that he cannot appeal and is forever barred from possessing weapons, are the final nails in the coffin of his old life. In under 15 minutes, Judge Stephanie Boyd systematically dismantles his future, delivering a punishment that extends far beyond the prison walls, ensuring his life in the United States is effectively destroyed. The drama isn't in shouts or tears, but in the cold, procedural, and irrevocable power of the law wielded with definitive authority.